Your Honour, Laura Clark of Counsel for the Crown. If you will allow me, Your Honour, I have some written material that I would like to tender in support of the Crown's case in the form of my written submissions. By way of background, Your Honour, on the facts provided to me by my instructing solicitor, on the day in question, the victim, a 70-year-old male, Mr. Joe, was withdrawing cash from an ATM in George Street of Brisbane. It is alleged that as Mr. Joe was using the ATM, Mr. Rocky, the accused in this case, assaulted Mr. Joe in an unprovoked attack. Immediately following the assault, Police Officer Jones attended the scene and assisted Mr. Joe until ambulance officers arrived. During Officer Jones's time with Mr. Joe, immediately after the assault, we have oral evidence which asserts that Mr. Joe was able to identify a specific tattoo identical to that of Mr. Rocky's, which I will discuss in due course. The following day, Mr. Joe passed away in Royal Brisbane Hospital as a result of a stroke, directly caused by the physical stress of the assault in question the previous day, which leads, obviously, Your Honour, to the charge of murder in this case. Your Honour, the Crown wishes to provide its opening submissions with respect to evidence in support of its case against the accused, Mr. Rocky. Firstly, the Crown will rely on the oral evidence of the first police officer whom attended at the scene, Officer Jones. Officer Jones will testify as to the oral evidence obtained from Mr. Joe immediately after the assault and before his death the following day. In Mr. Joe's oral evidence, and with respect to the man whom attacked him, he identified a specific tattoo of a cross on the attacker's left arm near his hand. Your Honour, we point out that the accused in this case, Mr. Rocky, has that identical tattoo on the exact location identified by Mr. Joe. This, Your Honour, is very strong evidence against the accused. The Crown asserts that this evidence is admissible by reason of the principle of res gestae. As Your Honour will see at page 7 of my submissions, Your Honour, I have outlined in detail the Crown's argument in this respect. Ultimately, the doctrine of res gestae concerns the admissibility of evidence by reason of its overwhelming relevance and reliability. This includes oral evidence made as part of the incident or events, and oral evidence or spontaneous statements made by participants of an event or incident in issue. The case in support of this doctrine is O'Leary, reported in 1946 at 73 of the Commonwealth Law Reports at 566. We point out that the oral evidence of Mr. Joe in this case, given immediately after the attack upon him, and by way of spontaneous statement with respect to Mr. Joe identifying tattoos on his attacker, it is strong admissible evidence in view of the doctrine of res gestae. Your Honour, the Crown's second submission relates to oral evidence obtained from Mr. Rocky in a police interview, wherein Mr. Rocky does not deny the assertion that he was seen at the pharmacy, which is in the vicinity of where the attack occurred. Further, when presented with the accusations against him, and when questioned about his attendance at that local pharmacy to collect his medications that day, he is recorded to have said the words, and I quote, "bugger," unquote, in response to those accusations. Your Honour, the Crown will submit that this is a significant indication that Mr. Rocky is without doubt guilty of the offence and the person responsible for the assault and subsequent murder of Mr. Joe. The Crown looks to a number of common law cases in respect of this issue. It is always a question, as it is in this case, of whether the words of the accused are such as to unequivocally adopt the truth of the statement. Further, Your Honour, the Crown asserts the defendant's failure to offer an explanation to contradict or call other evidence to the contrary also leads to the assumption of an admission of guilt, and this was supported in the case of Weissensteiner, reported in 1994 at 68 of the Australian Law Journal Reports at 23. And in the case of Joginder Singh Bains versus Yorkshire Insurance Co., reported in 1963 at 38 of the Dominion Law Reports at 417, an informal admission by the accused may be made by words or conduct and may be express or implied. Your Honour, the Crown therefore asserts that Mr. Rocky, by way of his response recorded in the police interview, and I quote, "bugger," unquote, this stands as a plain and clear admission of guilt, a clear admission of being found to be at the scene of the crime, being linked to the crime. Your Honour, the Crown asserts that this is a sufficient plea of guilt to the charges in this case, in addition to the evidence of Mr. Rocky's tattoo being identified by Mr. Joe. Your Honour, the third submission by the Crown relates to the evidence tendered by the defence, namely a statutory declaration said to have been obtained from Mr. Rocky's previous solicitor, which is ultimately a declaration by Mr. Rocky's brother, Mr. Shonky. In the said declaration, Your Honour, Mr. Shonky states that it was he who collected the medication from the chemist on that day in question, using Mr. Rocky's Medicare card, and that it was not Mr. Rocky who attended. Your Honour, with respect to this evidence, we point to the credibility of Mr. Shonky as a witness, as the Crown has discovered that Mr. Shonky is now housed in a mental institution as a result of a mental-related illness. Your Honour, plain and simple, the Crown asserts that Mr. Shonky is not in any way competent or compellable as a witness to this case in accordance with the Evidence Act of Queensland. We point out to Your Honour that Mr. Shonky is now held in a mental institution with mental-related illness and is not compellable to give evidence, and nor should his evidence be relied upon, given his mental state of mind. We therefore assert that the evidence put forward by the defence in this regard is inadmissible and not credible to any extent of the law. Your Honour, in presenting our submissions in the coming days, the Crown will call upon Officer Jones to give evidence, as well as a number of other reliable witnesses in support of the Crown's case. If it pleases Your Honour, that concludes the Crown's opening submissions for today. Thank you, Your Honour.